Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business, take up and consider SJR 68. Members, near the end of the 2023 legislative session, after the Texas House of Representatives passed articles of impeachment, Governor Patrick named me as chair of the special committee to recommend rules of procedure for the court of impeachment. In that role and from the lessons learned as chair of that special committee, I found the need for clarification and additional guidelines of the law governing both constitutional and statutory impeachment. SJR 68, in conjunction with the enabling language of Committee Substitute Senate Bill 2051, seeks to fix the inadequacies identified in 2023, as well as those identified upon my continued review of our impeachment process. Impeachment is neither a criminal nor a civil proceeding, but rather a delicate mixture of both elements of the two within the political realm. The powers relating to impeachment are a vital check in the balances between branches of government. In Ferguson versus Maddox, the Texas Supreme Court held that the primary purpose of an impeachment is to protect the state, not necessarily to punish the offender. Under Texas law, there are two types of impeachments: constitutional and statutory. Constitutional impeachment, contained in Article 15 of the Texas Constitution, applies to statewide elected officials, but Article 15 provides little to no procedural guidelines on the impeachment process. Statutory impeachment, contained in Government Code Chapter 665, applies to a state officer, a head of a state department or state institution, or a member, regent, trustee, or commissioner having control or management of a state institution or enterprise. While Chapter 665 provides extensive guidelines for the impeachment process of these officers, these provisions not only need improvement, but they do not apply to constitutional impeachments. This bifurcated impeachment process caused confusion among members of the legislature as well as Texas citizens because of the attempted application of Chapter 665 to constitutional impeachments. The insufficiencies in statutory impeachment guidelines and the lack of procedures for constitutional impeachment was evidenced during that 2023 process. SJR 68 proposes a constitutional amendment to address these issues and implement new provisions governing impeachment. Most significantly, SJR 68 creates a new constitutional provision under Article 15, Section 7, which would authorize the legislature to enact general laws to implement Article 15 or other constitutional provisions providing for the impeachment, trial, and removal from office or disqualification of any officer of the state. Article 15 of the Texas Constitution currently provides an overview of impeachment in Texas. However, it only applies to certain statewide elected officials and lacks procedural guidelines on conducting the impeachment process. This amendment would ensure that the legislature can implement general laws governing impeachment, including but not limiting to guidelines for House and Senate procedures when conducting an impeachment investigation and/or trial. Clarifying and implementing procedures for impeachment will provide future legislators more guidance on the process. SJR 68 also ensures that an impeached officer who is suspended from their duties will maintain their ordinary pay during the pendency of the impeachment. This would more closely align with state and federal impeachment, wherein an official is not stripped of benefits and pay until they are convicted. Lastly, Article 15 permits the governor to make a provisional appointment to fill the vacancy of an impeached officer. However, there are no prohibitions relating to the appointment when the governor is the impeached officer in Article 15. SJR 68 reaffirms Article 4, Section 16 of the state constitution, that the lieutenant governor will assume the duties of the governor during the absence or impeachment of the governor. This clarifies any questions as to whether the governor can appoint his or own temporary replacement. With that, Mr. President, I move suspension.